So let's start with the medical law and ethics. So first of all, medical ethics versus medical etiquettes. What are medical ethics? They are the moral principles. These, remember this word, moral principle, observed between doctor to doctor, patient and community in general. The medical etiquettes are conventional laws of courtesy. Remember this statement, observed between doctor to doctor. So, what punishment if does not follow medical ethics? Same punishment as that of infamous conduct. Okay, so example will also be same as that of infamous conduct. Infamous conduct we are going to discuss moving forward. Okay, same punishment as that of infamous conduct. And what's the punishment of infamous conduct? We are going to discuss further. Medical etiquettes, what will be the punishment if one does not follow medical etiquettes? It's no punishment. Medical etiquettes are good to follow, but not mandatory. For example, a doctor should avoid taking fees from another doctor. This is medical etiquettes. Okay. Now, coming to infamous conduct versus medical negligence. Infamous conduct is also called professional misconduct. What is it? Any disgraceful act with respect to profession by the doctor. Whereas medical negligence is lack of reasonable care and skill, which leads to death or injury of the patient. So, death or injury of the patient is a mandatory part to be called medical negligence, but not infamous conduct. Okay, so something can be called negligence only if some death or injury has occurred. Okay, who gives punishment for infamous conduct? It will be State Medical Council. Who gives punishment for medical negligence? It will be court. Which court? It can be either civil court or criminal court, depending upon whether it is civil negligence or criminal negligence. What's the punishment for infamous conduct? The punishment for infamous conduct is, number one is warning notice, and second will be then penal erasure, that is professional death sentence. Okay, doctor cannot practice as a doctor. He will lose his license. What's the punishment for medical negligence? What punishment can court give? If it is a civil case, the punishment will be fine. And if it is a criminal case, the punishment will be either fine or imprisonment. Imprisonment how many years? That we will discuss. Now, let us discuss the examples of infamous conduct. Giving or receiving commission with respect to referring a patient. That is dichotomy. This is dichotomy. How do you remember? Dichotomy, cut, taking cut. That is dichotomy. Caught is cut. Association with unqualified people. Doctor associates himself with people who are not allowed to participate in any medical procedure. These can be, there are two common types of association. One is qualified person performing surgery on a patient without his knowledge. The patient thinks that Dr. A is going to perform the surgery. He is anesthetized. Then some other Dr. B comes. He performs the surgery and the Dr. B goes back. This is called ghost surgery. Second is qualified doctor giving training to unqualified people, for example in ultrasound, so that they can do sex determination, okay, or they can do dilatation and curettage for abortion, okay. So he's giving training to those people who are not allowed to take training. This is called covering. So covering and ghost surgery are two kinds of association. All of them are kinds of infamous conduct. Now, medical negligence can be either civil or it can be criminal. So please remember, what's the difference between civil and criminal negligence? In civil negligence, Civil negligence, it is only a mild negligence. Civil negligence, it's a mild negligence. Criminal negligence is a gross negligence. Gross negligence. Okay, here the trial is done by a civil court. Here the trial is done by a criminal court. Here the injury is usually, not necessary, but usually mild. Usually mild, and here it is usually serious injury or even death would have occurred. Here the punishment is fine. Here the punishment is fine or imprisonment. Now, if I talk about imprisonment, please remember one thing. There are two scenarios. One is the death of the patient has occurred. Second is the patient is injured but alive. Injured but alive. That is, he might have suffered hurt or grievous hurt because of criminal negligence. So, I am talking about the injuries which have occurred to the patient because of criminal negligence. There can be two kind of scenarios. One is that death has occurred. Second is the person is injured but the person is alive. That is, hurt or grievous hurt has occurred. For here, you need not know the section. But if the death has occurred, the section is important. So, if death occurs, please remember, if death occurs due to any rash or negligent act, the section applicable is 106 BNS. 106 BNS. Very, very important. So, what's the punishment? A general punishment is up to 5 years. General punishment is up to 5 years. But for example, if a person kills another person in road traffic accident by driving in a rash manner, then he will be punished up to 5 years. So, general punishment for death due to any rash or negligent act is up to 5 years. For example, a person driving in a rash manner and killing somebody in a road traffic accident. But for medical negligence, the government has been considerate. Government has been a bit considerate. They say for medical negligence, the maximum punishment is up to 2 years. For medical negligence, the maximum punishment is up to 2 years in case the person dies due to gross medical negligence. Okay.